Good afternoon. We are remarkably on time for a day-long program, and I'm delighted that we will be able to wrap up with a panel of federal judges who will be talking about aspects of these statutes and related matters from their standpoint. Let me first introduce our panel. Sitting immediately to my right is my former colleague on this faculty, Judge Karen Nelson-Moore of the U.S. Court of Appeals for the Sixth Circuit. I could take up the entire time talking about her, but let me just say that Judge Moore taught procedure and tax law, and she may have been the only person in the room who understood my tax reference to one of the earlier speakers. She is twice a graduate of Harvard University, was an editor of the Harvard Law Review, clerked on the U.S. Court of Appeals for the D.C. Circuit and at the Supreme Court. In addition to teaching here, she was a visiting professor at Harvard Law School and was a much admired teacher while she was here. Beside her is Judge Solomon Oliver Jr., who is former Chief Judge of the U.S. District Court for the Northern District of Ohio. Before going onto the bench, Judge Oliver also was a law professor down the street at Cleveland Marshall College of Law, where he was also Associate Dean. Earlier, he had been an assistant U.S. attorney here in the Northern District, was chief first of that office's civil division, then of its appellate division. Judge Oliver has also taught political science at the College of Worcester, where he's a member of the Board of Trustees, I believe. And he clerked for the legendary Judge William Hastie of the U.S. Court of Appeals for the Third Circuit. Our other speaker is joining us remotely from Dayton, Magistrate Judge Michael Murs of the U.S. District Court for the Southern District of Ohio, where he has been on the bench since 1984. Before that, he was a judge of the Dayton Municipal Court, and he was a lawyer with a leading Dayton firm before his appointment to the bench. Judge Murs has never been a full-time law professor, but he is a longtime adjunct professor at both the University of Dayton and at Capital University. The way we're going to handle this is we will begin with Judge Murs, who will have some remarks focused primarily on the AEDPA. And then we'll go to Judge Oliver, who will talk mainly about the PLRA, and then Judge Moore will wrap things up for us. So Judge Murs, take it away.
Thank you very much, Jonathan. I am humbled to be involved in a panel, not just this panel, but the whole symposium, with people who know and have had much more experience than I have. But I hope intense judicial experience may bring something to this. The Southern District of Ohio has been for many years among the top 5 capital petitioner districts in the country. So we have a lot of capital cases in Southern Ohio. Let you all guess as to why that is, but we do and have had. I had my first capital habeas case in 1995. Since then, I've had more than 50 of them, beginning in 2000, all in the Western Division of the Southern District, and a few years after that, picking up some from the Eastern Division as well. Dennis Therese mentioned earlier that there was a magistrate judge somewhere in the state who was managing the lethal injection litigation, and that's me. I've had the management of that case since October of 2016. We have been in that case to the Sixth Circuit at least 6 times and several times to the Supreme Court. It gives me a pretty good perspective to talk about the difference between 1983 litigation and habeas litigation, and also the difference between capital and non-capital litigation. The AEDPA, I don't know what it's done for terrorism, but it has not made the death penalty in America any more effective. In fact, it's provided ways to slow executions. I won't say whether I'm in favor of that or against it. That would be injudicious. But it has the part of the statute that was supposed to make the death penalty more effective, Chapter 154, which was based on proposals Justice Powell made when he was president of the ABA, has been completely dead letter. It requires certification of compliance with certain standards in the prosecution of death penalty cases. And to the best of my knowledge, no state has sought that certification for many years, and no state has ever gotten it. So whatever there was some conversation earlier about purposive interpretation of statutes, whatever the purpose of Chapter 154 was, it has been completely negated by its lack of use. In Woodson versus North Carolina, the Supreme Court uttered the phrase, which is always quoted to me at least 15 times in any capital case, and that is that death is different. And I want to suggest two ways in which death is different. First of all, several speakers have talked about the value of having more upfront funding of attorneys in these cases. The capital habeas unit of the Southern District of Ohio, and there's also a capital habeas unit in the Northern District, is the most prepared, eloquent, strategic bunch of lawyers it has ever been my pleasure to work with as a judge. The Attorney General's side of the case is also litigated by folks who've been specialists. In general, in this country, we've wanted judges to be generalists, and I spent most of my career doing anything that came down the pike, but I've been able to specialize in habeas corpus for the last 8 years, and with the lethal injection case for the last 5 years. And I think specialization adds something. It certainly has added enormously to the expertise of the lawyers litigating the lethal injection case. In contrast, as many have mentioned, there are rarely lawyers in the non-capital habeas cases. I happen to have a habeas case pending with an imprisoned lawyer who's pro se, but other than that, most of them have no training. You can tell from case to case that the same jailhouse lawyer might be involved because of peculiar misspellings. But by and large, the non-capital habeas cases exemplify in every instance the over-proceduralization of habeas corpus that the AEDPA has strengthened, not created. Talk a little bit about the history, as I understand it, of habeas. I do not regard AEDPA, as some do, as a remarkable change in habeas corpus procedure, because I think it merely accelerated a change that was coming. Mr. Larkin mentioned Brown versus Allen as the case which expanded habeas to all constitutional claims. He didn't mention what is my favorite quotation from Justice Jackson's dissent, and that is that he who must search a haystack for a needle is likely to end up with the attitude that the needle is not worth the search. If you have to wade and wade and wade and wade and wade through points that are frivolous over and over again, you come to doubt whether there's any meat in the sandwich. An example about that hasn't been talked about is actual innocence. Judge Calabrese, and I wholly support his proposal about 2253C. Judge Calabrese talked about Schlupp versus Delo and the actual innocence exception. And in a case like the one he mentioned, where there's someone who probably is actually innocent, and one thinks of the House versus Bell case as well, it's easy to see the importance of pursuing that, maybe even to the point of recognizing actual innocence as a constitutional claim standing alone. The court hasn't done that yet, but it could. But looking for actual innocence, when one reviews 40 cases a year in which everybody claims to be actually innocent, gets you into a frame of mind of rather rotely reciting the criteria from Schlupp and from the Sixth Circuit's instantiation of the Schlupp standard in a case called Souter versus Jones, and telling people, the fact that you don't believe you're guilty, or that one of the people who testified against you has recanted, doesn't amount to reliable new evidence from reliable eyewitnesses or physical evidence or DNA evidence, for example. So I understand first of all, the motivation, I think the motivation for why the court continued after Brown versus Allen to expand the jurisdiction. I think it was largely because Justice Brennan felt the need to have some lower court judges who could enforce the Warren, and I would say also Brennan court expansion of constitutional rights. Look at the major cases decided early on in the 1960s. Mapp versus Ohio, 61. Gideon, and remember, Gideon was pro se until he got to the Supreme Court, when I think Gabe Fortas took the case over. Gideon is 63. Miranda is 66. Aguilar is 64. Malloy on privilege against self-incrimination is 64. Duncan, the right to jury trial in a serious criminal case, 68. There was, despite the fact that the Supreme Court at the time was deciding roughly twice as many cases in a term as it is today, there's no way the Supreme Court could take every one of the petitions for cert where somebody said, the Court of Appeals didn't get this quite right, help us enforce. And that's why I believe the court did what it did in 63, which really has expanded procedure as far as it's ever gone. Townsend versus Sane essentially gave practically every habeas petitioner the right to an evidentiary hearing, and where there wasn't a right, there was discretion anyway. Fay versus Noya decided the same day, said there's no, we're not going to block you out of habeas corpus on the basis of some procedural default unless the state can prove you deliberately bypassed a available state procedure. I believe the history of habeas corpus since then, at least since Justice Rehnquist became chief, can be seen as a largely successful rollback of the broad scope of habeas created by the Warren-Brennan court. Already in 76, you had Stone versus Powell, which essentially removes Fourth Amendment claims from our jurisdiction. Already in 71, you had the exhaustion requirement in Picard. In 77, Justice O'Connor introduces in Wainwright versus Sykes the strong procedural default doctrine that essentially continues today. AEDPA just accelerated that change. Of course, people have mentioned the one-year statute of limitations. For the first time, we have something like res judicata in habeas with no second or successive petition without approval of the Court of Appeals. And we have the explicit deference to state court decisions unless they're unreasonable. No one's mentioned this before, but some distinguished appellate judges have raised the point that making us look only to holdings of Supreme Court decisions is arguably a violation of separation of powers, and at the very least limits judges' looking at constitutional law, much more than they would be in any other area, even under 1983. So the AEDPA took us some substantial way beyond where we were, but I think it's the same arc as under the Rehnquist court, and it involves far too much proceduralization. And I have long felt it was an interesting question of justice, why a guy or gal, I presume we have no women on death row in Ohio, but why a guy who's sentenced to death should have two very fine, well-financed lawyers who do nothing else with their lives, whereas the guy sentenced to life without parole gets nothing but a jailhouse lawyer and a pad of paper to write on. So those are my observations about AEDPA, and I will turn it back to you, Jonathan.
Thank you, Judge Murs. Judge Oliver?
Thank you, Professor Entin. It's been a wonderful program. I've enjoyed it. You know, as a judge, we're sitting there on the bench and we're working on cases. And we really need to be exposed more to professors who think about these things every day, practitioners who spend a lot of their time working on these issues. That's important, I think. And so I've enjoyed the opportunity to hear presenters who appeared here today. And I congratulate a lot of you and those who assisted you on putting on this program. So as a district judge, we have a number of pro se cases, but by far the largest number would come from the PLRA litigation and also from the Habeas litigation. It may be helpful to know how we organize, and then I'll make some comments to handle these cases. In the Northern District of Ohio, we have habeas cases, except for the death penalty cases, to go to the magistrate judges, like Judge Murs. And Judge Murs, as you can see, has a tremendous experience in this area. And so that inures to the benefit of the bench there and out to the bar. I'm not sure we have anybody, I'm sure we don't, that has as much experience as he has, but most of our magistrate judges have significant experience, and of course they see these cases day in and day out. The death penalty cases, the habeas death penalty cases, we don't refer those to the magistrate judge. We handle those ourselves, and so unlike the Southern District where Judge Murs, Magistrate Judge Murs, is hearing the death penalty cases, we hear those that are assigned to us. We do have for our assistants a death penalty habeas law clerk. And so at least we don't have just the law clerks that we turn over every year, those of us who do every year or two, working on those cases. I heard someone refer this morning to the fact that you're a law clerk, you're there for 2 years, the judge gives a file to you, then you give the file to the next law clerk, and so it may be delayed that way. So we have some delay because the cases are difficult. And you saw the size of the transcripts and all the other aspects of the record that Dennis Perez talked about this morning. He talked about a record that was some 2,200 pages. And so it is a slow and tedious process, but each of the district judges would spend time on those cases with assistance of drafting from pro se death penalty law clerk, and that's how we would do those cases. On the PLRA front, the way we handle those is we have, as you saw from literature, if you've read it or if you have experience, we have a screening process. And there, again, we have 5 law clerks, pro se law clerks, and they screen the cases when they come in. And then they draft for us, if they think it's a frivolous case, they will draft an order for us. If they think it's not, then they will indicate that, and then we should go ahead and have the case, the complaint served, and the case would move from there. And then after that happens, then it will be strictly up to my chambers and my law clerks to work the case from there. So that's the process that we have. We do have pro bono attorney panel, but I must tell you, we really have not a very significant number of lawyers on that. And so when I look down the list to try to find someone when I've got a case where I say, looks like now this one should be moving forward, it'd be nice to have a lawyer on it. We just have such a dearth of lawyers that could hardly find anyone to do those cases or any of the others. And so I think that's an area that we do need to address in our own district, is to perhaps do something like I understand they do in Illinois, that when you sign on, for example, to the bar of that jurisdiction, that there is some requirement that you at least commit to do a case or something like that. May not be enough, but we need to find a way to get more of our lawyers volunteering to serve on pro bono panels to hear the pro se cases. You've heard how this works. All the PLRA cases are going to be essentially pro bono cases, and all of the habeas cases, except those at death penalty, are going to be without lawyers. And so and yet they have some of the most complicated procedures and limitations that exist in regard to any category of cases. And yet we expect them to jump through those hoops. You heard this morning, and of course, many of you, some of you worked in the area, and some of you as students that maybe don't have the exposure. And so we're talking to an audience that ranges in that regard. But you heard some of the limitations in the PLRA area. But one of the ones is that indigent litigants who are prisoners have to pay their own filing fee, unlike in other phone paupers cases. And so if they don't have the money, and they're not likely to have it, then they start drawing 20% monthly of their whatever they get from commissary, whatever work they do there. So they have that obligation. So again, that's something that would serve as a deterrent. Also, they have this I don't think people talk too much this morning about the 3 strikes rule, but they have that. So that if you file 3 cases that have been previously dismissed on the grounds of being frivolous or malicious or fails to state a claim, then you cannot file another case again. You can't file another case unless you can show that you're in imminent danger of serious physical injury. And then you heard the other limitations. You can't sue for emotional harm or recover for emotional harm unless you show physical injury. And then we heard some of the ridiculous fact patterns that were discussed where until there was a change in the law in Congress that courts were holding was not physical injury. And so those kinds of limitations are there. And you heard this morning a good discussion about the exhaustion requirement and how that really was the biggest impediment in terms of litigation in this area. And so, and there was some discussion about changes and so forth. So I think the discussion on those things has been quite adequate in my estimation. We do something about getting some attorney involvement in these areas, and perhaps we can do it in our district, but perhaps there should be some national attention to getting something like the Federal Public Defender's Office involved, at least in the cases that look like they may go somewhere. How do you decide that? Well, we've had COVID cases that we've been dealing with, and they were not 2241 cases, the kind they were talking about this morning, but they were cases on the 18 United States Code section 3582. Those are the kind of COVID cases that we heard the most of, not 2241. And that's where if the extraordinary and compelling reasons warrant a reduction in sentence, then the court can grant it, and it can do that if it's consistent with applicable policy statements issued by the Sentencing Commission. And so, we're working through those cases, and some people were released on those grounds. And what we did there, I'm not sure it can serve as a model, but there were a lot of pro se filings. And so we got the Federal Public Defender's Office to agree that they would do some screening, and that at least in those cases that they saw that had potential merit, that they would take on representation or file a supplemental brief. In other cases, they did not. They would just say they wouldn't opine on what the outcome should be, but they would agree to take those. We need to develop some meaningful way of handling these kinds of cases because they're far too complex, just procedurally. And yet, because I think people who talk about these things today have acknowledged that there are a lot of cases, there are flooded cases, there are a lot of frivolous cases. As a judge sitting there, I can attest to that. And so we can't deny that there are a lot of cases filed that really shouldn't be there, that shouldn't be in court. And the question is, how do we have sufficient screens or lens to get rid of those cases, but not lose the cases that should obviously be there and ought to be litigated? I think that's where sometimes we're losing out now, because we don't have adequate processes to make sure that those who do have legitimate claims get to pursue. So I'm not going to say too much more about PLRA other than I endorse the concerns that were raised, most of the concerns that were raised about the limitations there, whether they're too onerous without at least some ability to have an attorney, and that those that restrict attorney fees to certain amounts, or that's not reasonable, and that we ought to have some other changes in that statute. The one suggested by Professor Seiler this morning regarding exigencies or emergency circumstances, for example, I think that would be a good one also. But I wanted to raise just one thing in the area of the Habeas area with you, and that had to do with successive petitions and successive petitions in regard to Brady claims. And I think most of you know, the lawyers certainly do, Brady versus Maryland, which was decided in 1963, and basically involves suppression of evidence favorable to the defendant by the government. And so those claims often are raised in successive petitions because the defendant would not have the ability to know about the predicate for those claims. And so they're often brought in that context. And when it's brought as a successive petition, as many of you know, that means that you have a more onerous standard than you would have if it had been filed in the first petition. In the first petition, the standard is that the writ shall not be granted if the case was adjudicated on the merits, unless it resulted in a decision that was contrary to involved an unreasonable application of clearly established federal law, or resulted in a decision that was based on an unreasonable determination of facts. But if you go to the successive petition section, basically says two things. That you can't bring a claim if you had a previous habeas petition unless you show that the factual predicate for the claim reasonably could not have been discovered at the time of the initial petition. And two, that the previously undiscovered facts, if shown to be true, suffice to prove actual innocence by clear and convincing evidence. That's essentially what's required. And so, so often these claims are brought as successive petitions or attempted to be brought in that context. And the question is, should they be considered successive petitions? The law now is pretty clearly that they are, but the question is whether there is the movement, which I see in some of the cases, not really decisions, but what some of the judges are willing to say is suggestive that the law should be changed, or that the law could be changed through the courts themselves, or whether it should be changed legislatively. And I don't want to take too much more time because I think my time is probably running out. But I do want to. I think it's worth laying this out. there was a case called Panetti versus Quarterman, a Supreme Court case, 551 US 930. It goes back to 2007. It was a Supreme Court case, and it concluded that a second in time petition was not a second or successive petition because it involved a death row inmate who could not be, the sentence could not be carried out because it would be unconstitutional. He had that constitutional right, but he didn't raise it in his first petition, and now he's raising it in his second petition. Supreme Court said that's not a successive petition. Special facts there included the fact that he became insane after his first petition. And so the Supreme Court, after analyzing the situation, concluded that it was second in time, but not a successive petition. And so some of the circuit courts, at least in concurrent opinions and dissenting opinions, it suggested that Brady versus Maryland claims that a broad successive petition should not be considered second. And they're trying to do that by analogy to the Panetti versus Quarterman case. And so there was, just to put them on the record here in terms of what those cases are. One case where there's a concurrent opinion is Long versus Hooks, 972 Fed 3rd 442, the 4th Circuit, 2020 en banc decision, concurrent opinion by Judge Wing. And the case that I've seen that has gone the furthest in this regard is a case called Scott versus United States, 890 Fed 3rd 1239, 11th Circuit, 2018. It's a 2255 case, so it's a federal case, but analogous to 2254. And in that case, the 3-judge panel acknowledged that they had to affirm the district court would deny the writ, but they spent their entire opinion arguing why it is that this should not be considered a successive petition, urging their court to take up this case en banc so that so the court could reverse the prior reasoning in that circuit. And so those are two of the cases where even though current opinion and the other was an opinion where they affirm, they're suggesting that there's something special about Brady claims. The Brady claims go to the heart of the judicial process, the heart of fairness, and that when prosecutors have not turned over the information, they cannot be heard to cry that this somehow affects finality, the issue of finality and so forth. They do some reasoning by comparison to the Quarterman case in these cases, and I'm just touching the surface with this, but the suggestion is that when defendants in a Brady context cannot know about the information and they cannot proceed with it, it's not their fault. Why should they be disadvantaged? Relative to the standard that would normally apply, when in fact the state has affirmatively refused to provide them the information that they would be entitled to. It's not enough time to really go into a comparison of those cases and the arguments to Panetti versus Quarterman, but I think it's interesting development in literature in terms of the cases and something that perhaps may have some legs down the road.
Thank you, Judge Oliver. Judge Ward.
It's delightful to be here, and given that I was a law school professor here for 18 years, I'm especially happy to be back in the courtroom and to be joining you students and faculty and others who are here. The topics that we have for today, the PLRA and Edpa, are really very difficult and complicated areas. And I think we can see that in so many of these decisions that come out of the different courts. And I wanted, before I forgot, to mention the case that the situation that Judge Oliver was talking about involving Brady claims that arise after someone has filed their first habeas petition. Formally, the second and successive rules would apply. And I think Judge Oliver is raising a very significant question on that, and one that I was tangling with in the Sixth Circuit, and recently wrote a dissenting opinion in a case called Hannah, in which I argued that we should allow such a claim to be called simply second in time and not second or successive, but recognizing the error of my own ways in a previous case. So we sometimes face the questions about how to interpret these very complicated statutory provisions and realize with the benefit of further thinking and further briefing in another case that we should look more carefully. And so you might wonder then, why do we have such complicated statutes, the two, the PLRA and EDPA? What was the purpose of Congress 25 years ago in writing the statutes this way? And what is the purpose of the different federal courts, and in particular the Supreme Court, in its interpretations of the requirements? So to look at EDPA a little bit, EDPA really was the effort to restrict habeas. As Judge Murs points out, the Rehnquist court was restricting habeas from what it had been under the Warren court, but EDPA then imposed new statutory limits. And the limits involved imposing procedural hurdles, such as query whether it's procedural or substantive, the statute of limitations. So there was no statute of limitations before EDPA came around. That doctrines, equitable doctrines such as latches, were applied. But EDPA gives us a 1-year statute of limitations, and it's complicated as to how you count that year. So some of the previous speakers have spoken about, how do you reach the 365 days? Then there's the question whether the courts can allow for equitable tolling. And that was an unanswered question until certain cases came about, including a case that I worked on the circuit a long time ago, which is one of my favorite cases to bring out, Seiler versus Jones, which did allow equitable tolling. And it turned out that the individual was in fact actually innocent, that an expert had recanted, and normally witnesses recanting, trial courts are pretty reluctant to give any credence to that, but this was an expert witness who recanted, and another witness came forward, and the man who had been in prison for 14 years for killing a young woman, in fact, had not killed her, and was let out. And lawyers in that case sent word to the panel that the man was given money pursuant to the Michigan law compensating people for wrongful imprisonment. We also have, as a procedural rule in EDPA, the requirement of denying that federal courts must deny unexhausted claims unless there's an absence of available state process. And we've heard in the earlier sessions about the recent Supreme Court case that says it must be an available process. But what we haven't heard in depth is how detailed the state grievance procedures are and how easy it is for prisoners to trip up on meeting those grievance requirements. So in the 4 states in the Sixth Circuit, there are varying numbers of days, depending on which state you're in which you must file your first grievance about something that's happened to you in prison. And if you don't file that step 1 grievance within those few days, and literally it's less than a week, then you are out of luck, because the exhaustion procedure, the grievance procedure was available to you, you just didn't file your grievance. Now, there can be explanations, there can be equitable reasons that should apply, but unlikely in the vast range of cases. And then if you don't get a resolution of your step 1, you must seek step 2. if you do get an adverse resolution of step one, you must seek step two, and I can go on, but you can get the sense of how difficult exhaustion can be. We've talked briefly about the second or successive petition problem. If you get new information, can you bring a second habeas? There are very much stricter standards for that. But one thing we haven't really talked about very much during the course of today is what are the standards of review for merits decisions. So if the state court has resolved a constitutional claim on the merits, what is the standard of review in a habeas petition on that constitutional claim? And Edpa provides two provisions in 2254D that the federal court can grant habeas if the state court decision was contrary to or involved in unreasonable application of established federal law as determined by the Supreme Court, or if it resulted in a decision that was based on an unreasonable determination of the facts in light of evidence presented in the state court proceeding. So the whole question of what does contrary to or an unreasonable application of has involved extraordinary work on the part of various federal courts. Obviously, the Supreme Court is the one that tells us in the end what these provisions mean. But it is an interesting question. And I don't really want to go into lots of detail about Supreme Court cases, but there is a Supreme Court case that says that you must ask when you're in the unreasonable application prong, you must ask whether it's possible that fair-minded jurists could disagree that the arguments that are being raised are inconsistent with the holding of a prior Supreme Court decision. Must show, the state prisoner must show that the state court ruling was so lacking in justification that there was an error beyond any possibility for fair-minded disagreement. So the question for you as audience members is, what would you think that means if you're looking at what a particular state court decided in a particular case? And you also have to be looking at, what was the state court decision that you're considering? What the Supreme Court said affirmed? Do you look back at the prior state court decision? The Supreme Court has told us to do that. Do you presume a rationale for the state court? And these kinds of cases come to us every day, whether you're on the district court, a magistrate judge, or on the Court of Appeals. Every day we're having cases that are involving these kinds of questions. Talking about a case that recently went to the Sixth Circuit en banc and has been decided. It's called Taylor versus Jordan. And it involves a man who was convicted of murder the same day that the Batson decision was decided about allowing challenges to the use of peremptory challenges by, in that case, a prosecutor, peremptorily challenging the Black veneer people and getting a essentially all-white jury for a murder case. So the Taylor versus Jordan case is a death penalty case in the Sixth Circuit. It was decided the same day that Batson was decided by the Supreme Court. And interestingly, Taylor versus Jordan was prosecuted by the same prosecutor who prosecuted in Batson in the same county that Batson occurred in. And in Batson, there was a resolution Batson case held that there was going to be a three-step process for establishing whether or not a juror was being taken off the veneer on a peremptory challenge for unconstitutional reasons. In the Sixth Circuit, we had this case, we must have had 5 different opinions in the en banc case about what was the state court decision here, because there were several state court decisions. What was the operative one? We had several different views, varying judges having varying views on that. And we also had a situation where the state prosecutor had no reason to strike these jurors except for the fact that he believed that he could strike all but one Black person from the jury. That was what he thought the law was, and so he was striking all but one in this particular case. So I'm using that as an example to show how difficult these kinds of issues are when we're trying to decide, was there an unreasonable application of the law? What was the state court decision that we should be looking at in order to decide whether there was an unreasonable application of the law under Edpa? We also have the question of evidentiary hearings, and I think that some of the prior presenters went into this in very helpful detail. We have the question, when can the federal courts have a hearing in a habeas proceeding? And the basic answer is very seldom, but that's obviously not a good enough answer for any particular case. So Edpa imposed a variety of stringent requirements. I would dare to say that in many of our post-Edpa cases, we are struggling with all of these procedural aspects and must struggle with them before we can get to the merits. And that raises the question, why? Why should it be that way? Why should it be that hard to get to the merits of somebody's constitutional claim? Similarly, if we move to the PLRA, the provisions of the PLRA that Judge Oliver went through are another illustration of imposing procedural constraints that make it very hard for meritorious prisoner complaints to reach resolution. And I think, to me, one of the difficulties is provision allowing claims to be struck for being frivolous, malicious, or failure to state a claim before the other side is served, before there really is any development at all. How should it be determined whether a claim is malicious, frivolous, or without stating a claim? Normally, there isn't quite the leeway in other kinds of litigation that there is in the prisoner case. There are limits on filing fees, attorney's fees, limits on injunctive relief in prison condition cases, limits on reduction of prison size, a strict exhaustion requirement under the PLRA, and it's definitely the 25 years since the PLRA and Edpa have resulted in reductions of prisoner cases, the ability to obtain relief. So in a sense, they've been successful statutes in that they have burdened the prisoners and the courts with a very difficult set of procedural requirements that need to be satisfied before a claim.
Thank you, Judge Moore. Before we open up for questions, may I ask you if any of you have further thoughts or responses to anything that our panelists have said?
Judge Murs.
Yeah, I just wanted to comment on Judge Oliver's point about Brady claims on second or successive. A district court, particularly in a death penalty case, is in a cleft stick when the prisoner argues it's second in time and not second or successive. If we buy that argument and then go on to litigate the case, there's Sixth Circuit law that says district courts don't have jurisdiction to decide second or successive, if they are in fact second or successive. The requirement is that we must decide that in the first instance, but if we're wrong, we've made a jurisdictional error and we may have wasted a number of years of judicial time, because death penalty, death is different, and get it handed back to us. So I have always tended to err on the side of saying, if it's arguably second or successive, then I'm going to transfer it to the Sixth Circuit, which is where the Congress put the second or successive responsibility in the first instance anyway. I'm going to transfer it to the Sixth Circuit, and if they think I'm wrong and it's second in time, they'll tell me quickly, and I can go ahead. If they think I'm right, then they'll decide whether or not to grant permission to go ahead. But again, another example of the how over proceduralized AEDPA has made the whole habeas corpus jurisprudence.
I would agree with you. I tend to refer them to the circuit for that determination. I think that's the right process. I think the law has to change before we could be comfortable in terms of making those kinds of decisions. So if it looks like it's a second petition, because it's the second one, we send it down. And so almost always I would send it there. I think that there's a little bit of wiggle room, but not much in some of the circuits. And I'm not quite sure about the sixth. But if you find that in regard to the Brady violation, that it didn't just occur at the time of trial, but there have been things that have happened since that time where the prosecutor may not have come forward with information. It's a later point in time. And there are some cases like that in other circuits. Then they say that's a second in time, but it's not a successive petition. But that's not the usual case. Normally you're looking at facts from the standpoint of what happened at trial in that context. And even though the defendant doesn't know about what he or she has been denied, nevertheless, that's the act they're looking at. And so that would be successive. But sometimes there are lawyers who've taken, prosecutors who've taken steps to even cover things up after that point. And so then I think the courts have been split on whether that's successive or not. The argument in regard to why, and it hasn't been, it's not a widespread one that has been bought in too many places, but the argument in regard to the Brady is not just like in the Quarterman, the Panetti case. There, the person was not insane. I mean, at the time he filed the first petition. And so the court went through an analysis looking at habeas law and the purposes and all that. So that's a special fact situation. But the arguments that have been made now go really beyond just the notion that these are a new fact, it's a new facts added to the situation. They're basically just saying there's something fundamental about Brady and Brady violations that go to the integrity of the process. And so so they do analogize it to Panetti, but it really has to do with Brady claims, the nature of Brady claims, as opposed to other kinds of claims.
Other? Let's open up for questions. Anybody here in the room have questions? Up there.
Thank you all. A previous panelist noted that certain types of constitutional claims are essentially only able to be raised in collateral proceedings, like ineffective assistance of counsel, and there may be other examples I'm not familiar of. I'm wondering if all of the procedural limitations built into Edpa harm, in your view, the development of the law on that topic? And then maybe as a second part of the question, if yes, would it be possible to remedy some of that harm to the development of the law by addressing the merits question first and then the procedural question second, like the Supreme Court's directed courts to do for qualified immunity cases? Thank you.
Who wants to take that?
Well, it would be very frustrating to decide that somebody could win on the merits, but must lose on the procedure. I think, on the other hand, if the merits are clear that a person loses, that there are circumstances where we are allowed to decide that the merits are clear and the person loses. So, and I don't want to get into actual particular cases, but I think that happens with some frequency, that if there's a question in habeas about whether something is fully exhausted or something like that, might conceivably want to get to the merits first and decide against the petitioner, the habeas petitioner on the merits. But most of the time, habeas cases are, at least seems to me that most of the time habeas cases are resolved on a procedural.
I think you're right on that, but I do see cases where magistrate judges and then some of us would say, looking at the case, you can go ahead and go to the merits or do, maybe we shouldn't do it, but do kind of an alternative kind of analysis where you go ahead and do the merits. That may save time. It may not be considered to be proper, but it may save time by doing both. And I see that, and I've done that on some occasions. So that's my experience. But it's pretty hard on the effectiveness of counsel claims not to have those be raised collaterally. Because of all the reasons that were stated this morning, you got to wait until the person is there, and then the person's not going to be the person raising his or her own error. Now, of course, what I do when I sentence a person is I have the counsel file a notice of appeal for the person if they want one, but I always say that we will determine later whether you'd be the right person to pursue the appeal, and so we handle it that way. But you really can't in most appeals get at the ineffectiveness of the counsel. You've got to do that in another proceeding where you raise that, because normally it may mean also getting an affidavit from the person who's involved, and we see that in our 2255 cases quite often, where the defendants are raising ineffectiveness of counsel, and now the former counsel is giving an affidavit to the prosecutor about how he conferred or she conferred with the client and how they made them aware of all their options and so forth.
Ineffective assistance of counsel case, really a question, it's really a thorny one in terms of the last panel presentation on where do you present the evidence. Generally not going to be present in the original trial of the person in state court. Generally, appeals courts do not accept evidence, new evidence. So it has not going to be raised on direct appeal in the state court. So then the state court has this post-conviction process, but there's no right to counsel in post-conviction. So oftentimes the petitioner of the post-conviction will do the best job he can. But when we're talking about jailhouse lawyers, these are just prisoners. They're not lawyers who happen to be in jail. And if they were in jail, they're probably not lawyers who stole money or something like that. So maybe they've then become a specialist in post-conviction. But so then you've got a post-conviction in this pro se, and then you've got losing post-conviction. Hasn't presented evidence, say, at post-conviction, then you're at habeas. Well, maybe he's not a lawyer then. Maybe he's got better advice, and the habeas court would be able to think about should we, as a trial court, allow evidence? No, the question for the restrictions developing evidence in the federal habeas court is a thorny problem. We have this Martinez case from the Supreme Court that's helpful, but then we have this current case that's being litigated in the Supreme Court. About habeas of evidence. Really is a thorny problem.
Yeah, no, I just, it's quite different, and I think that while 2255s, and I think lawyers who practice in the area know what I mean, these are federal habeas cases, are quite different in some ways than 2254s. 2254s tend to be very complex. You've got the post-conviction process in state court, as Judge Moore talked about, and you're working your way through all that. And then you get to the federal court, and then the question becomes whether you need evidentiary hearing there and all that. In the 2255s, basically what happens is they file the 2255 instead of 2254, and the case comes back to the district judge. And also, that's where we would hear whether or not there was ineffective assistance of counsel. And so there would either be an affidavit or a hearing right in that context. So it's much shorter, much more compact, much more doable. And I don't think the same flaws exist in that part of the process that exists. Well, I don't know if flaws is the right word, but the delay and so forth. So our 2255s go fairly quickly. And if I feel like I need a hearing, I would have a hearing, or I would have affidavits or whatever I would have, and I would make those determinations. That would be the post-conviction process. It would not be the long drawn-out process that some states have, or some may not have any process at all. And so that's the complexity of it all, of what Judge Moore talked about. But 2255s were somewhat different. Judge Murs has had.
Just a comment about that. My understanding of the standard for granting evidentiary hearing in the 2255 is it's much more liberal, particularly than a 2254, particularly because Cullen versus Pinholster doesn't apply at all. That's a 2011 case for the audience that severely restricted evidentiary hearings in 2254s.
Yes, and I was speaking about the 2254 state.
Yeah, right.
Other questions? Matt, do we have any online?
This first question is for Judge Oliver. Are you suggesting that for Brady claims raised in a successive petition, the information need not be sufficient to show the inmate is actually innocent before the claim could be reviewed and a writ granted?
I am suggesting that there are opinions in some of the circuits that suggest that ought to be the case in successive petitions regarding Brady, that those claims should not be submitted to the more stringent standard of successive petitions, but to they should be subjected to the normal habeas standard. So that's the first thing. Yes, I'm suggesting. I haven't worked out an article or anything like that. I'm just raising this to the audience and suggesting that is some of the thinking that's going on, even on the courts. And one might ask, well, why are the judges, for example, in the one case where they're ruling against the petitioner, saying, but we think, and I don't know how many pages, 15, 20, 30 pages, that the law is wrong in our circuit in this area. That's the one case, the 11th Circuit. And the other case was in the 4th Circuit, the concurring opinion, where the judge is saying that we think that it is not consistent with with Edpa to the purposes of the statute to subject these Brady claims to a successive petition requisites. That's what I'm saying. And then the analysis, some of the cases, for example, the Scott versus United States case, the 11th Circuit, goes through what it purports to give as an analysis of why the case is similar to the Panetti versus Quarterman. I didn't go through the analysis by comparing it to that case, but that's what they purported to do in that case. Yes.
We have another question. This could be for anyone. Several tensions regarding Edpa's statute of limitations have been resolved by the Supreme Court instructing prisoners to file premature protective petitions in federal court and then request stay and abeyances to exhaust in state courts. In your experience, have pro se prisoners been able to navigate this additional procedural hurdle? Has the push for protective petitions had a noticeable impact on federal dockets?
Great.
Judge Murs, go ahead.
Oh, sorry. Yeah, I see a lot of petitions filed with a motion to stay filed right with the petition, arguing that that we have to let the state court decide the unexhausted claims first. I also see pro se petitioners asking for stays when they don't have any unexhausted claims. So I'm not sure that there's complete understanding of the need for a stay, but I see a lot of pro se motions, and they all know that Rhines v. Weber is out there. So it's certainly not an insuperable burden, I don't think.
And one more question from the chat. This could also be for anyone. What about the revelations that some previously recognized forensic sciences are now recognized as junk science and not real science? How does someone raise that as an issue if there's no Brady or IAC claim to raise with it?
Excellent question. And you know, this is not usual that science proceeds and that something that was considered a truth earlier on is no longer considered a truth. In terms of like fire analysis, apparently changed dramatically as to whether something is arson or not over time. And I think it's gotten some notoriety from, I think it was from Texas, about somebody who was convicted of killing his family by setting fire to his place, and I think he was executed.
Willingham.
Sorry, I didn't remember the name. I'm terrible with names, but the gentleman was executed, and it turned out that the science was wrong. Really a stunning problem.
We have a parallel case pending here in Dayton, a man convicted on the basis of fire science 25 years ago of murder, and the district judge has decided to treat the question. The case is not referred to me, but district judge has decided to treat the question about the competing fire science ideas as a question of actual innocence, and is intending to hold an evidentiary hearing on that question, has set one, as a matter of fact.
Well, this case that I wrote a long time ago, Seiler versus Jones, would be an example where the expert had said at the state trial that the mark on the decedent's head was caused by the bottom of I believe it was a beer bottle. It could have been some other kind of alcohol bottle. And then 10 years later, the guy actually got habeas counsel, And the habeas counsel re-interviewed the expert, and the expert said, well, actually, when I'm looking at this now, I realize this could not have been caused, this mark on the decedent's head could not have been caused by a beer bottle or alcohol bottle. And so the question is whether equitable tolling should allow the habeas petition to be
Right.
filed late. And we did allow it to be filed late. And then that was when not only did the expert recant, but also somebody came forward whose father had been driving strangely that night and had, it turned out the father's truck mirror had hit the decedent on the side of the road and the father had driven off. The father was now dead, so he couldn't testify or anything, but the combination of facts led this gentleman to be released from prison and ultimately to be able to get some compensation for something like 14 years in jail. But Michigan doesn't have the death penalty, so he was not
Right.
subjected to the death penalty, whereas here in Ohio, Tennessee, and Kentucky, among our 4 states.
And I think this actually reflects a kind of intellectual tension between law and science, because in law, we are concerned, among other things, with finality, whereas at least the philosophical underpinnings of science are that everything is tentative and subject to refutation, although presumably we don't think we're going to have to reconfirm the law of gravity every morning. But the underlying premises are very different, which creates tensions not only in this area, but in a number of other areas where science and law interact. Other questions? We need to get this so that the folks online can hear.
Oh, I see. I'm just responding to the person online. We actually, from the Capital Habeas Unit here in the Northern District, we do have a case with where science has evolved such that bite mark evidence was used in the person's original trial. It's no longer considered a valid science. So just in terms of litigation strategy, the first place that we started was in state court, because we're now asserting this person's actual innocence, or at least their actual innocence of the death penalty, so that you can, there's rules in state court under Ohio law where you could start. And then once you've exhausted that, which we did, then you go back and assert a second in time habeas petition, saying that this obviously couldn't have been discovered at the time of the trial. And I think that's pending in the Sixth Circuit now somewhere. So.
Other questions or comments?
Make just one comment. Just back to the issue that I was raising, Panetti versus Quarterman, and whether it should be extended to second habeas petitions relative to Brady. I guess the question is, why should that be, or why would one argue that? The problem is because you've got this extra hurdle on successive. It's more difficult, and so impeachment evidence is hardly ever sufficient in that context. So unless you got the smoking gun, you got the person who's recanted, you've got some significant person who's recanted, or some other way to prove the person is actually innocent, you're not going to be able to proceed. It's a much more onerous standard. The first one is onerous enough, but the idea is that if you come up with impeachment evidence on a successive petition, you're probably going to lose, and that's why it's coming to the fore as it is.
So first of all, I have to go to my Uber in 6 minutes. So I apologize in advance if you're responding to my question. I stand up and leave. So I think this is this discussion about like what to do with tool mark evidence or bite mark evidence, or the Cameron Todd Willingham stuff about arson science or biomechanical science, all these new science claims, right? there's a lot of new state statutes that allow us into state post-conviction proceedings to do this stuff. And the lawyers appointed in federal court tend to be very creative about how to get into state court to do those things. And it's kind of my position that federal habeas law is so removed from the realities of like the way claims are presented and litigated now, that reformers should focus their efforts on improving representation and access to courts and state judiciaries. And I'm wondering if you share my cynicism about federal habeas law, and if we're serious about enforcing rights, whether a lot of us academics who spend a lot of time writing about federal habeas law should maybe spend more time on state post-conviction stuff.
I don't really know about how the states are in our circuit in terms of how receptive they are.
Judge Murs?
Yeah, I would say that the suggestion is a good one, particularly because sometimes it's easier to convince the state legislature than the Congress. But there are more procedures available in theory in Ohio post-conviction that are actually very good at implementation. So you're supposed to, there's a possibility of appointment of counsel, where I rarely see that. There's a possibility of discovery. I rarely see that. There's a possibility of evidentiary hearing. I rarely see that. And my thought is it's probably because of lack of judicial resources as well as attorney resources. So that's probably a good place to focus for reform.
Judge Oliver, you want to add anything?
No, I do think that sometimes you see what appear to be deficiencies in the state court process that seems not to be as, I guess, you don't see the expertise down there that you see in the federal system. Now, some of the lawyers are working both ways. For example, I have lawyers that we allow them to pay them to go down to the state system and work on unexhausted claims and so forth. And I've done that in the past. So I have lawyers who work both in our court and both in the state system. And I think they've been pretty good at pursuing those, but that's not available to every litigant. So I do think that I see sometimes problems in the record and the way cases have been developed, which give me pause when they get to the federal side. I don't know about having people who are devoting a lot of the time on the federal side. I think we just need more. Because it's just such a complex area. And maybe there should be more overlap between those who are doing the state work and those who do the federal work. But I applaud the people on the federal side. The ones I've seen who do it regularly are really quite good.
Okay, let me ask again, questions? Yeah.
A few times over the course of the day, it's come up the important gatekeeping role that Edpa and the PLRA serve, and keeping out frivolous prisoner litigation and the preservation of judicial resources. We've talked about that a little bit, but I was wondering what your take was with regards to the judicial resources that are spent litigating these procedural issues. If we're spending a lot of time on exhaustion, second in time versus successive petitions, calculating the statutes of limitations and things like that, are we just redirecting the judicial resources to these procedural issues? Or are we actually having an effective gatekeeping role that does something worthwhile.
I can say something about PLRA very quick, and then, because I think that one is easier than the other. I don't think we're devoting a lot of resources to PLRA. And maybe, and I worry sometimes we're not devoting enough. You know, we have these cases screened by law clerks, and they're good at it. But if you're not careful as a judge, you're getting 5 or 6 of these a month. And you know, you don't want to get to the point where you just kind of rely on them to do those things, and then you just 6 of them off your docket. And I because they're coming constantly, but they are those don't take, most of them don't take a lot of time. The few that we get that remain are the ones that take time. They're difficult because if they don't have lawyers, and they're the worst kind of cases to be in, where you can't serve as a lawyer for them. And yet, you know, you want to make sure their claims are heard. But I don't think that's a big judicial use of. We don't spend a lot of time. I think my colleague would agree with me on that. We don't spend a lot of time on the PLRA cases. So I just wanted to address that one. Most of them are screened out, and the ones that are left, there are not that many ones that actually go to judgment in favor of prisoners. So that's not a lot of time. I think the time is in the other area, and I just wanted to address that part.
In the habeas area, I think if I were able to write Edpa or to calibrate the Supreme Court's decisions, I would focus more on allowing the merits to be heard as a lot of time saying procedural requirements were not satisfied, and they're quite staggering how many people miss the 1-year statute of limitations, don't have, because they're sitting in prison and they don't know really what's happening, and a lot of the people are not very well educated. Think that they can start the counting of that chart that someone had earlier today. It's very sad if someone is barred by the the 1-year statute of limitations. They're in prison, they don't have access to the internet. They not have their legal papers with them, and so forth and so on. It's unfortunate to have this 1-year statute of limitations. Why not go back to the approach of latches, which was used before, and say, all things considered, did this individual bring the case in? That's just one example of how sad it is that we have to be counting all these days very carefully and then decide about the petition. Whether the person has a meritorious claim. It's my position. My role as a judge is to follow the law. And I follow what Edpa says, I look at what the Supreme Court says, I look at what binding precedent in my circuit is, and I follow the law. But if
Judge Murs wanted to get in.
With respect to the screening under Rule 4 of the habeas rules, I completely concur with what Judge Moore said. I would rarely raise the statute of limitations defense sua sponte in a Rule 4 proceeding. About the only time I would recommend dismissing a case on the basis of Rule 4 is if it's on a statute of limitations basis would be, it's like 20 years late. But if we get a petition that is based on non-cognizable claims, like somebody says the trial court admitted hearsay against me, that's not cognizable, and so I'm not reluctant to use Rule 4 as a screening mechanism for those kinds of claims. But I am very reluctant to to raise statute of limitations or even more procedural default sua sponte. That's why the Attorney General's available to litigate these cases.
I don't think I would do it sui sponte. And I agree with the sentiment of what's been said, but I also recognize the difficulty of proceeding in that way. The question is really, in almost any area of litigation, you gotta have some timeframes. And so maybe you want some exceptions to the timeframes, but you want things to move along. It seems to me you can't just let a case sit and then a person can bring it anytime they want. And so I certainly embrace sentiments of Judge Moore on this in terms of doing more on the merits. But I think we have to think very hard about how do we bring that about in a way that allows courts cases to move at least in a timely fashion. It has to be some cutoff, but I would be for some exceptions. And she talked about some of those. I don't know that law very well about laches and so forth, but it seems to me if you had a cutoff in terms of like 2 years or whatever the year was, and then some exceptions to it, you maybe could accommodate most of the cases, but you're gonna always have some that are just too far out. I think.
Okay, other questions? We are at the end of a very long day, so let me first thank our 3 judicial panelists for their and it is my sort of institutional role to wrap things up and to recognize some folks who made this program possible. First, this is a law review symposium, and I want to recognize all of the law review students who have been involved in making this program go successfully today. There are something like a dozen associates who have, I may have the number wrong, but a whole number of second-year students who have made this program work well, and I want to thank them. I also want to repeat something that Dean Berg said when she convened the program. We have been generously supported not only by the law school, but by the Attorney Admissions Fund of the U.S. District Court for the Northern District of Ohio, by the Northern District of Ohio chapter of the Federal Bar Association, and by the Federal Litigation section of the National FBA. And I want in particular to thank all of those folks, because we could not have made this program work without their support. And some of the folks online are FBA people. One person in particular, I think we need to recognize, and that is Eric Seiler, who is the person who checked most of you in today. Eric works with the law review and our academic centers to make programs like this possible at all, taking care of all of the nitty-gritty details that mere faculty members like me couldn't possibly master, because they're kind of above my pay grade. So I want to thank Eric in particular for making today go so smoothly. Finally, as I said, this is a law review program, and I'm going to kind of maybe violate protocol. I want to recognize Andy Rumschlag, who is the editor-in-chief, who brought the idea for this symposium to me. This was a student-generated idea, and they pulled this off. And Andy was one of those. And the other person who is the symposium editor and who will help to make sure that many of the presentations from today will wind up in a special issue of the law review in a few months. Reagan Joy, I think Andy and Reagan also should get a separate recognition here. And I think we are done. I assume that everybody who's in for CLE credit got the appropriate paperwork, and if you did not, let me know. I don't know the answer, but I will make sure that you get your answer. Thanks again to everybody. Have a wonderful weekend and a good Thanksgiving. Take care. I also